Okay, so good afternoon, everyone. My name is Vânia Wongtschowski Kleiman, and I have been kindly invited by Arbitration Channel to interview Nigel Blackaby, co-author of what is called the Bible on International Arbitration, the book called Redfern and Hunter on International Arbitration. The 7th edition of the book has just been released, and is exactly about this new edition and about other points, if we have time, that we are going to talk today. So I would like to start thanking Arbitration Channel for the invitation and for the opportunity. And well, although Nigel doesn't need an introduction, I can mention that he is a partner and co-head of Freshfields Latin America, practice based in Washington, D.C. He has acted as counsel and arbitrator in over 100 arbitrations conducted in English and Spanish, including over 50 investment arbitration. He has particular expertise in Latin America and energy and mining disputes. Nigel is widely recognized as a leading authority in international arbitration. He is ranked Band 1 in the Chamber Latin America Guide, has been selected for the Legal 500 Hall of Fame, and recognized as a global leader by Who's Who Legal. He was also appointed Queen's Counsel for Excellence in Advocacy by Queen Elizabeth II. Now he's King's Counsel. Well, Nigel is co-author of Redfern and Hunter on International Arbitration, 4th, 5th, 6th, and 7th editions, Guide to Exceed Arbitration, 1st and 2nd editions, and International Arbitration in Latin America. Nigel also serves as an adjunct professor of investment arbitration at American University Washington College of Law. He's a member of the Court of the Singapore International Arbitration Center and of the International Commission of the Centro Internacional de Arbitraje de Madrid. So, Nigel, welcome. It's a great pleasure and privilege to have you here and to be able to have this conversation with you. Welcome.
Thank you. Thank you very much, Vânia, and for Arbitration Channel for this invitation. I very much look forward to our conversation.
Great. So, before starting to talk specifically about the book, I would like to know if you could tell us a little bit about your professional background. If you could tell us how and when did you start to work with arbitration, both as counsel and arbitrator?
Thank you, Vânia. Well, I studied law in both England and France. I did a dual degree in English law and French law. And following that, I took my professional exams and joined Freshfields in 1991, and then joined the litigation department after my training in 1993. I'd always been fascinated by the idea of advocacy, international and comparative law, but I wasn't quite sure how I was supposed to fit all of those passions into my career. And then I met Martin Hunter, who was a partner in the litigation department at Freshfields. And he approached me one afternoon and noted that he had an arbitration under US law concerning a cruise line in Miami. And he needed me to go out and collect some witness statements and some documents in Miami, which to a young English solicitor in the middle of an English winter was a very exciting proposition. So I said that sounded great, except I really had no idea what arbitration was or was about. So he thrust a copy of what was then the 2nd edition of his book in my hand, told me to read it over the weekend, and then head off to Miami early the following week to do the job. So that was my first experience with arbitration. I never really looked back following that. I did as much work as I could with Martin and then with Alan and with Nigel Rawding, who was another partner at the firm who specialized in arbitration. So I was involved in all kinds of things very early on, from Nigerian oil projects to Indian satellite disputes. I had a very interesting case involving a joint venture for the purchase and sale of a collection of modern art. So that was really how it all began. I did some very interesting work with Jan Paulsen, who of course needs no introduction as one of the world's leading arbitrators, with regard to the International Court of Justice case of Bahrain against Qatar. And I spent some time out in Bahrain working with Jan on preparing that case, which our client, the Kingdom of Bahrain, ultimately won. And then I got involved again with Jan and at the time Johnny Vida in some very early treaty arbitrations, investment arbitrations in the mid-1990s against the Russian Federation. And that really, in turn, positioned us well to work on the first wave of Latin America cases involving the Argentine crisis. And we worked on over 10 of those cases for our clients and were successful in all of them, albeit at a stage when the law was at a very early stage in investment arbitration. And following that, in between sort of Bolivia and Ecuador, and then the Hugo Chavez regime in Venezuela, which led to many expropriations, we have been extremely busy ever since in Latin America. We built up a great team. I have a team of about 20 lawyers in the Latin American arbitration practice who work with me, many of whom are trained in the region. And in parallel to the investment cases, we have a thriving commercial arbitration practice, including in Brazil, where I've had the good fortune to work on a number of big Brazilian cases, including big fight between Telecom Italia and Brazil Telecom back in the early 2000s, and then the fight over the control of Pão de Açúcar between Abilio Diniz and the Casino Group of France, and more recently, the working with the JBS Group on its dispute concerning the acquisition of the Eldorado Paper and Cellulose Group, and more recently on a post-M&A dispute involving the acquisition of a Brazilian metals business. So that's been absolutely fascinating and very, very diverse, I think. In parallel to that, I began working as an arbitrator in my mid-30s, so going back now about 20 years, largely focusing on commercial cases. Probably about 80% of those cases have been in Latin America, including a large number of cases in Brazil. So I've learned a lot about Brazilian law in my work as arbitrator as well as counsel. So that's been fun, as has the opportunity to travel to Brazil frequently, albeit I'm much more of a carioca than a paulistano. So I always try and get as much work as I can involving the oil industry, so I get sent to Rio rather than to Sao Paulo.
Well, I don't blame you for that. And well, a very quite interesting and impressive experience you had. And you mentioned that you met Martin in Freshfields. And what about Alan? He used to, or he still works there, or he used to work at Freshfield as well. You met him there?
Yes, Alan was the head of the litigation practice. In fact, he founded the litigation practice at Freshfields. If you think about now, the hundreds of lawyers who work in our disputes practice worldwide, Alan was the very first one, and he founded the practice in 1967, which was the year I was born. So, Alan goes back a long way. It was really his brainchild, and Alan was instructed on some very early arbitrations involving the government of Kuwait, and he needed some help with those cases, and borrowed Martin Hunter, who at the time was working in the corporate department, and he never gave him back for the rest of his career. And together they decided, actually it was Martin's original idea, but he convinced Alan it was a good one, to write a book that built upon their experiences in those early sort of seminal arbitrations in which they participated, that began to describe from a practitioner's perspective the workings of an international arbitration, not purely from a perspective of one country, which had really been the tradition up to that date. What is arbitration in the UK, or what is arbitration in France, or what is arbitration in Germany, but truly international arbitration, looking at general principles that are applicable everywhere, and using case law and experience from every continent to effectively feed that discussion and that book. And that became Redfern and Hunter, which is still alive today, many years after its first edition.
And how you came to be involved in the revision of the book with Constantine Partasides? Partasides?
Yes, well, it was Constantine and I were both working in Paris in 2002. I'd gone out to Paris in 2000, and Constantine had been there a little before me, and we'd both worked with Martin and retained contact with Alan, both of whom were still in London. And Alan took us out for a very nice dinner in Paris, and suggested that we might be interested in working on the book and taking it forward together with them, so effectively to become two additional authors. This was obviously rather daunting, but nevertheless, an amazing opportunity. And of course, I didn't hesitate to say yes, and neither did Constantine. And so from that moment onwards, we became involved firstly in the edition that was then pending, which was the 4th edition, and then with every edition moving forward. But it was that fateful dinner which led to us becoming involved, and fortunately, they've retained their confidence ever since. So we've continued to be involved.
And how did you feel, and how do you feel to take on such a huge responsibility to reveal the Bible of international arbitration?
Yeah, it's a bit like an actor being asked to sort of to review the next edition of Hamlet. It was something that felt very onerous, but nevertheless a fascinating challenge. I'd learned my trade by reading. It was the very first book I ever read on arbitration, as I told you earlier. It was a heavy responsibility, particularly as you can imagine, and as you know yourself, being a busy practitioner, trying to find time to make sure that you do the work necessary to make it a worthwhile review is hard. But we had a good team of young lawyers who helped us with the research, and we managed to make it happen by dividing up the tasks and then having periodic sort of editorial meetings with Martin and Alan to go over different chapters and to test and make sure we were covering what we needed to cover. So it worked pretty well. On the division of labor, we pretty much, each edition, we share prime responsibility for particular chapters, and then as the edition changes, we switch so that we're never responsible for the same chapters. And that makes us more alert and stops us getting complacent. So that's how we've done. And then Alan, as you know, Martin passed very sadly, but Alan, with this last edition, has had a very active red pen. I think it's as a sort of a seniorish partner at my firm. Not many people review my work, but Alan still does. And he does it in the old-fashioned way with the red pen. And he's very liberal with his red pen. And the book is much better as a consequence, because Martin and Alan were very keen on the style of the book, which is quite direct, with short sentences and with ideas that are illustrated as opposed to being an encyclopedia. We're very grateful for his sharp eyes on our prose, and I think that the book is better for it. But that's how we go about working on the book.
Well, it's such a privilege to have Alan reviewing your
yes
work.
It is.
Well, and in general terms, what have been the main updates in the 7th edition, and why? What were the reasons why you made such updates?
Well, I think it's the 7th edition. We wanted it to be more of a rewrite than other editions. I think there's always a risk when you have a multi-edition book that you have an update exercise, and of course the underlying principles of international arbitration have not radically changed. There's been evolutions which we must properly reflect. At the same time, we must not be sort of attracted to the latest trend and spend too much time focusing on something that perhaps in the next edition would not be so important. So we want to make sure that we don't forget the basics, but at the same time that we keep very much up to date. But sometimes the examples that we use become a little out of date, even if they illustrate the point well. So we try and come up with new examples. But of course, since 2015, which was the 6th edition, the last 7 years, a lot of things have happened. I think we'll come on to chat about it a little bit later, but we've lived through the pandemic, which had a huge impact on the practice of arbitration as as so many other professions. As a consequence, partially of the pandemic and other things, including pressures for more transparency, most of the institutions have changed their rules since 2015. We've seen everything from this SIAC, SIAC in 2016, the LCIA in 2020, the ICC and the ICDR in 2021, and last of all, ICSID in 2022, which was rather frustrating because we were about to publish, and then ICSID published its new rules, so we had to pull everything back and make sure we were fully incorporated the new rules of ICSID, which we did. But that all had to be brought in, and those changes addressed, because of course a lot of the book is looking at the way in which the major institutions operate and the rules which they apply. So it was critical that we reflected the latest rules. We also needed to sort of address the soft law. As you know, soft law of international arbitration is very important. We had the new IBA rules on the taking of evidence, the second version from 2020, the ICC note to the parties and arbitral tribunals on the conduct of arbitration in 2021. So we've seen some changes in the soft law, as well as the way in which soft law has been used. So we needed to do that. So we looked carefully at the way that soft law has had an impact. Sociologically, I think there's been a real change in the last 7 years in the practice of arbitration. You will have been aware a lot of the focus on diversity, which started with the Equal Representation in Arbitration Pledge, which was spearheaded by my partner Sylvia Nuri in our London office, which really aimed at making everybody think very carefully to ensure that we were maximizing the opportunities to have an equal representation of women, both as arbitrators, counsel, and as speakers at conferences, etc. And I think when the last edition came out, the sixth edition, it was a nice idea that was just getting off the ground, but by the seventh edition, we'd really seen some progress. I think you wanted to make sure that was reflected in the book. So we have a discussion about the pledge. We have a discussion about the very recent emphasis on trying to obtain more racial diversity in arbitration. We also talk a little bit about the massive carbon footprint of international arbitrations and how to campaign for greener arbitrations, which my colleague Olivier Andre is working on, are sort of hot topics in terms of modernizing the way in which we practice arbitration and the people who are involved in the practice of arbitration. So that was important to reflect. Similarly, there have been some interesting changes in the world of mediation, which is, I think, difficult to talk about arbitration without talking about mediation. We've seen the UNCITRAL model law on international commercial mediation in 2018 and the Singapore Convention on international settlement agreements resulting from mediation in 2020. So, two big changes there that are trying to make mediation more attractive, and we're definitely seeing more mediations than we did, although probably there's still more room to grow and avoid full-fledged arbitration with many disputes. And again, as usual, there have been some new arbitration laws and some adaptations of existing arbitration laws. So in Argentina and Uruguay, we've seen new laws. We've seen a revision of the Swiss private international law, which governs arbitration in 2021, which is very important given the dominance of Geneva and Zurich as seats for international arbitration. And we've also seen changes in the region, including things that have happened in Latin America, such as the changes in Brazilian law to allow public entities to arbitrate, the changes in 2015 and supplemented in 2019 that we wanted to make sure fitted into the book. So really a whole host of different things that we wanted to reflect, to make sure that we included new topics as well as updating the older topics that we'd already addressed.
Okay, you mentioned pandemic during that started in 2019, 2020. So it was in between the 6th and the 7th edition, right? That the world was like locked down for pandemic. And maybe you could go a little deep on that and tell us what was the changes in the world of arbitration that were reflected in the book? Yeah,
well, it was pretty revolutionary. This was a major change. I mean, arbitration is a very human profession. I mean, we're constantly meeting, whether it's in conferences or at hearings or in meetings. So to suddenly tell an arbitration lawyer that you can't actually physically have contact with someone, it's very hard to imagine how one would go about continuing to exercise the profession. So this was a major change. I mean, until the pandemic, remote hearings, by computer had taken place for procedural hearings, largely for economic purposes, to avoid the cost of everyone traveling for a half-day hearing, or for urgent applications. So, I have an interim measure application. I need to have it heard next week. We'll have it done on video. So it was possible. It had been done. But I had never experienced an entire final hearing by video, or how one would go about doing that in my, well over 20 years of experience at the time. So it was very hard to think about how that would work. It was very interesting. It was very personal in the sense, because I was actually in Sao Paulo in March 2020 in a final hearing. And we were week one into a 2-week hearing. And just at the end of week one, it was when the US began closing down flights. And it just dawned on us, because Brazil was obviously later than Europe and the US with regard to the pandemic. And so we felt a little isolated from the risk in Brazil. But that suddenly we could actually get locked down in Brazil. And I think the president of the tribunal realized this risk and said, look, everyone's got to get their flights changed, get out of here as quickly as possible. We'll finish up witnesses tomorrow, and we'll reconvene in 2 weeks' time virtually from wherever we happen to be, and we'll work on a protocol for that in the meantime. So literally, I mean, we had one day to try and sort everything out. My wife called me from London, where she was at the time, because ironically, I was about to become a QC, so the ceremony there was supposed to be happening, but again, in the middle of the pandemic. And I was told to please go buy a suitcase and fill it with toilet roll and hand sanitizer, because that was impossible to obtain in London. So it was all very strange. And then we got back, and then literally within a week, we had to learn what was Zoom. How did you use Zoom? How did you use effectively an electronic hearing bundle? What was the protocol that you should use for a cross-examination through video? How did you deal with consulting with your colleagues when you weren't present with your colleagues? How did you make sure that all the witnesses were genuinely on their own and not receiving prompts from behind the screen? All of these questions that we hadn't really asked ourselves before had to be answered. And so in the first instance, we had to kind of make this stuff up and try and agree it with the opposing party and the tribunal. And then a few months later, the institutions began issuing different protocols on issues to consider for running remote hearings. You have, for example, the ICDR virtual hearing guide, or the ICC on proposed clauses for cyber protocols, etc. But all of these questions, revised hearing hours. I mean, suddenly everyone's in different time zones, so you can't have a hearing day of 7 to 8 hours. It needs to be 3 to 4 hours, because someone's in South Africa, someone's in Australia, someone's in France, and someone else is in the States. You can't expect people to cross-examine someone at 1 o'clock in the morning. So all of that had to be taken into account. But it was fascinating in a sense. It really was remarkable how quickly the industry and lawyers adapted. But I think it was a way in which I think arbitration embraced technology for the first time, and probably jumped ahead 10 years in the space of 3 months, because suddenly we all were forced to have to learn new tricks. And being a conservative profession, as most lawyers are, we prefer not to have to do that until the very last moment. So I think it made us all aware, and we quickly adapted to the new normal. Now in the book, we obviously reflect all of this. It comes up in lots of different ways. The organization of the arbitral tribunal, where we look at it in general terms in chapter 4. There's the power to order remote hearings. One of the big questions was, at the beginning of the pandemic, what if a tribunal orders a remote hearing over the objection of one of the parties? Will that then give rise to a risk of set-aside or annulment? That was a big fear, because none of the rules actually addressed that question head on. So obviously for a party that's a respondent and wants to delay things, objecting to a remote hearing with an undefined pandemic and lockdown could buy them an extra year or two. And so, ICA, the International Council on Commercial Arbitration, commissioned various reports from different states to confirm what the position was, so that people wouldn't be frightened and tribunals wouldn't be frightened to order a remote hearing over the objection of one of the parties. Fortunately, the answers were all positive. There was no basic rule of due process in any of the main jurisdictions. But these were all issues which we haven't had to confront before. So we've addressed this in the book. And of course, there's a legacy, because of course we're out of the pandemic now, but everyone has now done remote hearings. And so whilst I think the general sense is that on the larger hearings or the hearings involving large financial sums, people are now having physical hearings again. I started having physical final hearings again since last September. Nevertheless, there are certain hearings which it makes sense to do remotely. And in fact, I had a remote hearing last October, which was nothing to do with COVID. It was just a question of the economics. It was a case which didn't really warrant everybody traveling from all over the world and spending money on planes and hotels. And when it was going to be a 3-day hearing, and so, we all agreed to do it from our offices, and we all knew how to do it because we'd done it during the pandemic. So there has been a shift, although obviously, of course, for the larger cases, we have gone back to physical hearings. But it's been a very interesting experience, and one that I think taught the arbitral world a lot, and in turn has led to the part of the campaign for greener arbitrations is, do we need to leave this carbon footprint of having 50 people travel to one particular destination in order to have these cases resolved? That in certain circumstances, we should be thinking of doing things in a manner which doesn't involve the printing of everything, where you can use electronic hearing bundles, where you don't need to travel all of the time, and where you can accordingly reduce the carbon impact.
The carbon footprint generated by travels is so huge, isn't it?
It is.
Yeah. When we stop to think about it, it's something very impressive. I believe that virtual hearings is something that something positive from that the pandemic left us, exactly because sometimes it's possible to do virtual hearings, although in-person hearings sometimes are necessary, of course.
Yeah, I think it's much. I mean, it's obviously much nicer to have that personal contact, particularly when, and also as an advocate, I think you lose a lot of the adrenaline of the hearing, where you have that team spirit that we're all working there at 1 o'clock in the morning trying to get that next cross-examination script ready, and everyone's kind of on a high because they're just working towards that common goal. I remember doing a final hearing in our Paris office with 4 screens, me, nobody else, at 10 o'clock at night doing cross-examinations because of the time difference. You just don't get that same sense of sort of excitement or sort of enthusiasm or team spirit. So it's good to have that back. I must say, one of the benefits of the pandemic was the ability to participate in conferences all over the world without having to travel, because I think sometimes for a busy practitioner, you can sometimes lose almost a week if you've got a long way to travel for a conference, whereas participating in a conference, much like we're doing today, via a remote link, it enables you to continue to participate, but without that effort, and then to get back to your day job more quickly.
Yeah, that's right. You're right. I agree with you. And well, you were mentioning before a few changes in institutional rules, and in the book, I noticed that you included a topic, a subheading, that was related to emergency arbitrators and expedite arbitrations. Could you expand a little on this subject?
Yeah, I mean, I think emergency arbitrators have been a relatively recent creation, and we saw it in earlier editions of the institutional rules. And they've become a much more widely used tool now to obtain interim relief at a moment prior to the constitution of the tribunal. Of course, historically, certainly when I was starting out, if you needed interim relief before you had an arbitral tribunal in place, you had to find a suitable court to go and ask for that relief. which in a sense obviously negates the party's intention to arbitrate, because once again you're having to rely on the judicial power to provide you with relief. Kind of flew in the face of their intent. So the figure of the emergency arbitrator responded to that concern, and it does work very well in terms of providing a quick response with someone who's appointed quickly, where you need to stop on a bank guarantee or prevent evidence being destroyed or whatever the urgent situation is. And the problem was in the earlier versions of the rules is that the emergency arbitrator provisions were opt-in provisions. So it was, here exists the tool, but if you don't have anything in your arbitration clause, then it didn't apply. And the reality is, as we know from our corporate colleagues, that the arbitration clause is not the clause they spend most time on. And if you get them to actually follow the standard clause of an institution, you're already lucky. If they're actually thinking about opt-ins and opt-outs, you're in an exceptional situation. So in reality, they were a bit of a dead letter, because it was very rare to see an opt-in unless you were, with the odd exception. So now with the latest set of rules, we see it's now opt-out or they're there. So basically, it is part of the menu of options available to parties in arbitration. Now, of course, one of the big concerns, which remains a concern, is that what happens if a party doesn't comply with an order of an emergency arbitrator? Because the order of an emergency arbitrator, much as it would be from the arbitral tribunal, is an interim order and is not an award under the New York Convention. So it doesn't benefit from the enforcement provisions of the New York Convention. And as such, if a respondent doesn't comply, there's not much you can do about it. But of course, it doesn't bode well for the results in the underlying arbitration, but it doesn't have the same power of imperium as the judicial courts would if they had issued it. So that risk still remains. Interestingly, some jurisdictions have addressed this question. I think Singapore is an interesting one, where in its International Arbitration Act of 2012, it requires the courts to enforce interim and emergency arbitrator orders. So that's something definitely that every jurisdiction should look at when considering its amendments to its laws to make that, at least on a domestic level, enforceable directly, so that the orders of emergency arbitrators don't become a dead letter. But certainly a lot of improvements, and the latest set of rules that I think don't make them opt in anymore will lead us to see far more emergency arbitrator applications.
Great. There's a specific question there I'm very curious about to hear what you have to say, which is related to Chapter 10, Item F of the new version of the book, where there is a topic about state responsibility for wrongful setting aside. I'd like to know if there was any important decision from courts regarding this matter that prompted you to include such a topic.
Yeah, this is kind of a strange topic if you think about it. Everyone thinks that once you have an award in a particular seat, that you kind of take the risk of the seat, and therefore if the courts of that seat annul the award, then that's the end of the story. Now, one way around that might be to try and, if you think it's been wrongfully annulled on the basis of a strange public policy, you could seek to enforce it somewhere else. There are some jurisdictions that will go behind a setting aside and say, well, we'll enforce it anyway if we don't agree. But this was a different point. This was a point where you had an award and where the claimant, in a case called Saipem against Bangladesh, which was already there for the 6th edition, but there was another case which happened more recently, where effectively Saipem, the claimant in an ICSID case, brought a case against Bangladesh because of the actions of the courts of Bangladesh in wrongfully annulling an award. And the tribunal, the International Investment Tribunal in that case, held that Bangladesh had expropriated claimant's investments, it being its rights, that had effectively been crystallized in the award. So that was an interesting, very interesting decision, I think, which showed us how international investment tribunals were not frightened of attacking court decisions. I think there's always been a fake respect, not fake, but an undue respect for the judicial power in international investment arbitration. under international law, the judicial branch is just one branch, as the legislative branch or the executive branch, and it shouldn't be afforded any more deference than any other branch. You can have courts that don't do their job, as you can have executives that don't do their job. So that was important, because it's not just limited to denial of justice, which some authors and arbitrators seem to think. That's clearly wrong as a matter of international law, and SAIPEM held that. And it held Bangladesh to its responsibilities. But interestingly, there was a very interesting case that happened against Italy by a company called BEG. And this was a case of the European Court of Human Rights, because in that case, Italy had upheld an award, even though the Italian courts had upheld an award, even though it was very clear that one of the arbitrators was not independent of the parties. And it was quite blatant. I can't remember the exact facts, but it was quite blatant. And the claimant in that case brought a claim before the European Court for a breach of Article 6 of the European Convention of Human Rights, which is a right to a fair trial. And he said, I didn't get a fair trial because the arbitrator lacked independence, blatantly lacked independence. And the European Court, said that the article did apply to arbitration, that you don't waive your rights to a fair trial just by going to arbitration, and that the conduct of the Italian courts in upholding the award was a breach of Article 6 of the European Convention on Human Rights. So again, quite different from the SAIPEM v. Bangladesh case, but another example of where an international court or international instance has effectively punished a state and held a state responsible for wrongfully setting aside or wrongfully not setting aside an award, depending upon the case. So that was kind of why we wanted to sort of draw attention to that a little bit more. It doesn't happen very much, but it does show you that it's not necessarily the end of the road once a domestic court annuls the award that your client's relying on.
It's a very interesting topic that would deserve a whole book for it.
Yes, yeah, I think I have a former colleague, Professor Massimo Benedetti, who has written some fascinating articles on human rights and arbitration, precisely dealing with these issues, which I highly recommend everyone to read.
Great. So, Nigel, changing a little bit subject, but not that much, could you please go into a little bit of detail about the updates related to investor-state dispute resolution? You mentioned in chapter 8.
Yeah, no, that's I mean, this is one of my chapters, so I hold it dear. I shouldn't really reveal which is my chapters and which aren't, because
it's our chapter in this edition. In the next one, it won't be anymore.
Exactly,
right?
Exactly. So this is an area of constant development. It's an area where I spent a lot of my time practicing, and we saw a lot of changes since the last edition, in particular the new ICSID rules, which have really focused a lot more on transparency. Now, for example, awards are automatically public. They're not subject to the consent of the parties for their publication, although the parties can request redactions. We've seen again on the transparency front, just as the last edition came to print, we've seen the UNCITRAL rules on transparency for treaty arbitration, but now we've seen that they're being used and what their impact is. All of this is really trying to respond to the backlash against investment arbitration, which has been very strong and very bitter over the last 7 years, by saying, okay, one of the criticisms was lack of transparency. Here's the transparency. You can read the awards. Parties can elect transparency. A lot of the treaties that involve investment arbitration, the bilateral investment treaties, or the free trade agreements now require transparency in their latest iterations. Other things involving transparency, the need now to identify the existence and identity of third-party funders. For example, if you're being funded, you need to confirm that fact, identify the funder. That's for purposes of conflict of interest. We address in this edition the furore, of course, one big case which threw the cat among the pigeons in European investment arbitration was the ACMEA case of the European Court of Justice, which basically resulted in the supposed incompatibility of the dispute resolution clauses of intra-EU BITs. That's to say, any BIT entered into between two states that are members of the European Union, those BITs can no longer use, or parties or investors can no longer rely on the dispute resolution provisions of those BITs. Now, this has resulted in a huge fight between arbitral tribunals asked to resolve those disputes and the European Union, which has openly said that the incompatibility means that effectively the treaties are unlawful per se, whereas the tribunals, I think correctly as a matter of international law, have said that European law is not superior to the international law contained in an international investment treaty. And the European law doesn't have the power to terminate or somehow negate the rights that have been established in a treaty. Once a treaty has to end, it has to end on its own terms, not because some other supranational institution says so. So we've seen I think some 50 tribunals pushing back and telling the European Union it's wrong. But the problem is that politically, the member states have all fallen into line and have terminated their intra-EU BITs in order to be seen as good citizens by Brussels. So in a sense, there's been a whole chunk of investment arbitration that no longer exists, which is sort of the investments into Central and Eastern Europe. And now we're seeing that even more, which didn't get into this edition because it's more recent, the pressure of the European Commission for the European Energy Charter, it's not the Energy Charter Treaty to be effectively terminated for similar reasons. So there's been a huge political fight by the European Union against investment arbitration, which has been victorious, I think, simply because of the power of the European Union. Similarly, other parts of the world have seen backlash as well. I mean, if you look at the USMCA, which is the successor of the NAFTA treaty, the investment protection provisions have been absolutely gutted. They're only a small portion of what they were before, with so many preconditions that their actual utility may be questioned, and indeed preventing disputes with Canada pretty much altogether. So we're seeing this reaction, ironically, more in the Western world, in the Northern Hemisphere, from Europe and from North America, whereas ironically in the Southern Hemisphere, which frankly, probably 90% of the respondent states are from the Southern Hemisphere, investment arbitration is alive and well. So it's rather ironic in a sense that Europe is up in arms, even though European countries relatively rarely respondents in these cases, with the exception of the solar cases involving Spain and Italy and those cases. But in general terms, it's been the Southern Hemisphere which has retained, and we've even seen Ecuador peculiarly leaving ICSID and then going back to ICSID again in 2021. So it's the only country that's ever left and returned in the space of less than a decade. So it still serves a very important purpose. But in investor-state arbitration, there's been this huge political tumult. Of course, there have been a lot of developments in the substantive law and the procedural law, which we reflect as well. But we wanted to make sure that this debate is not something that we don't confront or address in some way in the book. So we've done that.
Great. Well, talking about different jurisdictions, in your opinion, which jurisdictions have shown the best development in terms of arbitration and support of their respective state courts?
Yeah, I think it's hard to pick out a specific example, but I think one has a sense when you practice, which seats are on the up and which seats are on the down and which seats are on the steady. I think the classic seats still remain very strong. I mean, you think about London, Paris, Geneva in Europe, they remain very much, I think, the leaders, although The Hague is an important seat as well. In terms of the Americas, New York in North America, I think New York still is very strong. We see some developments in Miami, but the big cases still tend to be heard with a seat in New York. Washington, I would do a plug for Washington, wouldn't I, because I work here, but although it's obviously ICSID's seat, and therefore where just about all ICSID cases are heard, I think there's been a bit of a spillover because a lot of the arbitration bar that's based here also does commercial cases. So we're seeing quite a large number of commercial cases in international arbitration here in Washington. I've been nominated on a number of panels in international arbitrations with a Washington seat. So I think the importance of Washington has grown. But similarly, I think in Europe, the importance of Madrid is growing. I think there's definitely a sense that Madrid is on the up. We're seeing firms developing their Madrid practices. We've developed ours. We've seen recent new offices from other firms in Madrid. Now in South America, Sao Paulo is by far the most important seat, largely obviously in respect of Brazilian disputes, but because of the size of the Brazilian market and the importance of ICC in Brazil, it really has become a major seat. And I've sat in a lot of cases with the Sao Paulo seat as arbitrator and also as counsel. So I think there's a huge focus there. I think the decision of the ICC to open an office, which was also during the last 7 years as well in Sao Paulo, has been a terrific idea that really creates a sense that the ICC is a Brazilian institution as much as it is a Parisian or an American or anywhere else. And that has created, I think, a real buzz around the ICC and led to, I think, Brazil being the second user of ICC services globally, which is quite an achievement. If you think about where Latin America was 20 years ago, no one would ever have dreamed that would be the case. So I think these are all strong seats. Paris, there was a bit of a I think a little bit of a blip when for a period of about 2 or 3 years, the courts were annulling or partially annulling a large volume of investment arbitration awards. And one stage it was around 50%, which was way above what one would normally expect for annulments. That didn't happen in commercial arbitrations, but it suggested that there was some degree of politicization of the French courts with regard to investment disputes, not positive to claimants. That seems to have corrected itself largely through the work of the Supreme Court, the Cour de Cassation. I think has put the principles back where they should be in terms of the allowing tribunals to do their job and not interfering with the merits. So Paris is still very strong. So I think nothing has really changed. I don't think we see the same names. I think if there's one change, which is noteworthy, it's the continuing rise of Singapore. Singapore really has become a major force in international arbitration, particularly through the work of SIAC, which is one of the most sort of dominant institutions in the world and going well beyond Asia now. And I think it's picked up a lot on the risks that people now see inherent in Hong Kong as a consequence of the increasing politicization of the judiciary in Hong Kong and the fear of the control of China. So a lot of that work has now flowed through to Singapore. Not all of it, but Singapore's clearly taken up the slack. So I think it's definitely been 7 years where Singapore has grown in importance.
Okay, so from an international perspective, how do you see the development of arbitration in Brazil, and how was your experiences with arbitration? How were your experiences with arbitrations in Brazil?
Well, I think arbitration in Brazil is very strong, and it has been strong. I think for the big international disputes, it really is the only game in town. The ICC has, as we said earlier, obtained a great deal of power. Of course, there's the CCBC and other very important institutions. But Brazil, unlike just about every other jurisdiction in Latin America, not exclusively, but I think it's certainly a prime example of where we have seen a sophisticated arbitration bar develop. You're a great example yourself. I have many colleagues I've had the great pleasure of working with. I won't name them, but they're all good friends, and there are highly sophisticated international lawyers, who run large ticket international arbitrations. It's the only jurisdiction in Latin America where, when we come on as counsel, we're usually genuinely just co-counsel. The Brazilian counsel lead the case, and we assist in certain international points, or in selection of arbitrators, or in helping to refine strategy, but where we don't lead the case. Every other case where we've got a commercial case in Latin America, typically we would run the case, and it would be supplemented by local counsel providing input into local law and local practice. It's the opposite with Brazil, which I think reflects how sophisticated the market has become. But beyond that, I mean, I think you see that the courts, are respectful of arbitration. They are staying away from interfering unnecessarily with arbitration, although there are plenty of, ways in which the judiciary can be involved. And I think Brazil is probably the most aggressive litigation culture I've seen outside of the US, far more than in other countries in Latin America. So parties can be very, they're very aware of the tools that they can use through the judicial process. But in general terms, I've been impressed with the way in which the Brazilian courts have addressed these issues, and they do so in a relatively timely fashion. So I only see good things in terms of arbitration in Brazil, and particularly given the amounts involved and the complexity of the issues and the disputes, that will only continue. So for that reason, I continue to practice my Portuguese.
Great. That's a good idea. And well, Nigel, in Brazil, as you may know, our Arbitration Act applies both to domestic and international arbitration. We don't have a separate regime for international arbitration. So is it desirable, in your point of view, to have a unitary statute that applies both to domestic and international arbitration?
I think it's a bit of a yes and a no answer. I think one can see the benefits of a unitary approach is that you have one arbitration bar that's applying one set of rules, that there's no confusion as to what principles should apply. And generally, provided that the unitary approach is an international approach, that's good. The concern is when the unitary approach becomes dominated by domestic concerns that aren't really applicable in an international context. So I think as a concept, it's best to have a unitary system. In practice, it may depend upon the way in which arbitration is used domestically. Because I think in some jurisdictions, I mean, for example, let's take an example of Colombia, which I know reasonably well. I mean, every commercial dispute is pretty much resolved by arbitration, however small. When my wife's a journalist, whenever she's had to sign a contract, it's everything's got an arbitration clause in it. Even relatively small, every consumer issue has got an arbitration clause in it. And so sort of applying a set of international rules to those kind of disputes is not necessarily the most appropriate. And so, one sees in domestic arbitrations, a reflection more of domestic judicial rules. And perhaps in some circumstances that may be more appropriate culturally. Obviously, in international arbitration, for example, on disclosure of documents, it's very much a sort of a hybrid approach, half informed by the common law world, half informed by the civil law world. But for a domestic arbitration in a civil law context, is it really appropriate to have sort of a semi-discovery approach? The answer may be no, because that's not the culture that the courts would have. So I think it depends upon the way in which domestic arbitration is used. If, in general terms, domestic arbitration is something used for commercial disputes, and that domestic or consumer disputes are resolved through the courts, then a unitary approach is less worrisome. It just worries me when we get into consumers, very small contracts, or very domestic issues that they're trying to apply as one size fits all. Cannot necessarily be the best response.
And it will also depend on pretty much on the law, right? On the Arbitration Act. Like if the law follows the model law,
Exactly.
Maybe.
Yeah, it's very hard to give a general answer. I think it depends very much on what the rules are, what the particular unitary rules are, or what the sort of the alternative is. Yeah.
Okay, so you were talking about arbitration related to consumer relations, and I would like to know if you see in different jurisdictions a tendency to broaden the spectrum of arbitration. I ask you that because in Brazil there have been some changes in the legislation to allow, for example, arbitration in labor agreements, subject, of course, of some requirements. It's now being discussed here if arbitration in tax matters should be allowed. I would like to know if this is a tendency you see worldwide, and what is your personal opinion about it?
Yes, I mean, we've certainly seen it, and we've seen it in Brazil for public contracts. I think the tendency is not to have reserved areas anymore. It's to say, well, look, I mean, provided you trust the system, there's nothing inherently wrong with having an arbitral tribunal decide certain specific matters. The concern, obviously, is where those matters sort of have a sort of an erga omnes effect. So, a tax matter, what if one arbitral tribunal determines that a tax statute should be interpreted in a particular way, and then another one decides in a different way? How do you deal with precedents? And one thing is perhaps on a general legal concept, but you can't have a tax being applied differently in the same country. So you just need to ensure how do you adapt to those kind of issues where a single decision, particularly if it's public, could have a broader impact. But I think generally the sense is that unless you've got a very good reason not to have the topic arbitrable, then it should be arbitrable. I think the one exception is genuinely with regard to consumer contracts. I think we've seen recent French and US cases that are pulling back or are being reticent to read in, for example, consent to arbitration. Obviously, consent is in arbitration needs to be in writing under the New York Convention. And in general terms, case law has been very generous in saying that a cross-reference to a set of standard terms which refer to arbitration is fine. But there's been a bit of a pushback on that with regard to consumer contracts because there really is no option in many cases, and sometimes the references are rather they're not very direct. And in those circumstances, we're seeing, I think, for consumer protection purposes, particularly in France and the US, that some arbitration agreements are held not to be valid vis-a-vis consumers because of the nature in which the contracts were concluded. So I think in that sense, I don't think there's an expansion of arbitration in consumer terms. But otherwise, I think there is. So I think in anything that's commercial or or doesn't affect consumers, I think we'll continue to see that expansion, which is fine. I think that arbitration should be available for everything, unless there's a good reason for it not to be available, because ultimately you have to consent to it. So if you want to have an arbitration rather than go to court, why not? Unless there's a very good reason.
Especially because arbitration is about consent, so
exactly.
Why not?
Exactly.
Great. So what are, in your opinion, the main challenges in international arbitration nowadays? Is it still efficiency in terms of time and costs?
Yeah, it's hard to say now. I think that there are so many challenges as well as so many opportunities. I think the time it takes now for awards to be rendered, particularly in investment cases, is too long. The cost has increased too much. There's been an increasing, I think, judicialization of arbitration, meaning that there's been a sort of an accumulation of rules, which are obviously helpful. They can help establish common standards, but at the same time, it sort of leads to multiple rules applying, and the more rules you apply, the more chances that someone's going to claim that they're not being applied. So, I think that, I think the guidelines of the IBA on conflict of interest are very, very helpful. But of course, if anyone doesn't comply with them in some way, even if they're just guidelines, that often gives rise to an arbitrator challenge. So in a sense, every time you have a set of rules, you also sort of multiply the risks of procedural incidents. I think as well, arbitration and arbitrators, I still think, don't feel well equipped to deal with bad behavior of counsel. I think there's this sense that they're not judges, that they're always in fear of the award being challenged, and that therefore, the gut reaction is to let things pass and just allow the other side an opportunity to respond, and then ultimately, continue, but often after a delay and cost. And I think that's one of the biggest challenges now. I mean, the conduct of counsel now is quite shocking compared to what it was 20 years ago, where really everyone was just focused on the merits and get to the merits. And it was a small community of arbitration practitioners, and we all knew what we had to do. And let's focus in on the merits of the case and get to an answer. Whereas now, there's so many different groups involved in arbitration, and where some litigious cultures and have led to, I think, what we've seen sort of guerrilla tactics in arbitration, which I think just means sort of constant applications. I mean, we've seen in one of our cases 7 challenges to the arbitral tribunal. And when you know that every time you challenge, you're suspending the case, and there's nothing you can do other than just every time that they challenge, you have to suspend, you have to decide, and there's no other penalty. You have to give arbitral tribunals the tools to do what they need to do, not just with regard to the parties, but also with regard to counsels, to allow tribunals to do their job. Because I think in some circumstances, tribunal members are just getting fed up, because when you sit as an arbitrator, you just want to get on and decide the case. And of course, there are certain procedural safeguards that need to be respected. But I think one of the biggest concerns about arbitration is the increasing cost, precisely because of the number of procedural incidents. If you look at the number of arbitrator challenges or procedural incidents now compared to even 10 years ago, it's multiplied. And that's a concern, because I think arbitration, once when we started doing arbitration, one of the benefits was, well, it's cheaper, it's more efficient, and it's confidential. And it's no longer cheaper, it's no longer more efficient, and it's not really very confidential. So basically, arbitration now is there sometimes because it's the only game in town, as opposed to having real benefits that people used to give it. So I don't think any arbitration practitioner should be complacent. I think there are a lot of improvements to be made. And I think efficiency, and I think as well ensuring that tribunal members also prepare their award promptly and don't overtrade, so that we're not waiting. I think the average now is well over a year for an exit award from the last date of the post-hearing brief, so probably 18 months from the hearing, which, when I first started, if your average award would be 3 to 4 months after the hearing. That's multiplied by 4 or 5 in investment cases. Not so badly in commercial cases where the institutions follow up more assiduously, but nevertheless, I think it's it's something that the institutions need to be aware of, and because clients get very upset. I mean, they don't want to wait 4 or 5 years for a decision. So plenty of challenges, and we should play our role in resolving those challenges rather than in feeding.
And what do you think is causing this change of behavior? It's just that there are many people involved that come from different cultural backgrounds, not like arbitration councils. What's the cause of that, in your opinion?
I think that's part of it. I think that's part of it. I think, and maybe it's because it's no longer the community that it was. I mean, it really was a very small community when I started. I mean, some of the sort of the conferences now where you see 1,000 people going, there used to be 60 of us, and we would all know each other. And, people say, well, that's not very good for independence and impartiality. But in reality, everybody knew they had to demonstrate their independence all the time in order to remain credible. But there was a sort of a mutual respect that you wouldn't do that kind of thing. they might be opposing counsel, but you respect opposing counsel and you wouldn't expect them to behave in a particular way. A lot of that's fallen away. I don't know what it is, whether it's society more generally. I think we've seen the polarization of positions through all kinds of other social phenomena. But I think the way in which arbitration is seen as a game, and to try and obtain different benefits by applying different pressures that are different from simply those relating to the merits of the case is unfortunate, and it doesn't do arbitration any favors. I'm not a sociologist. I couldn't point to the exact cause, but I can certainly point to what we see in practice.
Okay, well, those that work with international arbitration knows that cultural differences are something very important in the arbitration proceedings, and it's something very common. So, based in your experience, your professional experience, what are the best methods to overcome cultural differences?
Yeah, I'll be just talking, I guess, a little bit about cultural differences leading to some concerns. I think, the best way, in spite of perhaps hurting or contributing to the judicialization of arbitration, if the soft law rules and recommendations that make clear what the rules of the game are important. And I think if you look at the two paradigm examples of the IBA guidelines on conflicts of interest or the IBA rules on the taking of evidence in international arbitration, they have been absolutely fundamental in establishing basic ground rules as to how an international arbitration should take place. And I think that's very important because before they existed, you really would see two radically different approaches. You'd see the civil lawyer coming with a civil law sort of procedure approach. We don't have any disclosure of documents. We just decide what we want. And if the tribunal wants more, it will ask more, but there's no inter partes exchange of documents. And then the common law lawyer coming in and saying, we want full discovery and you have to disclose every document that's relevant to the issues in the case. That kind of issue was resolved by, this very careful drafting of the IBA rules on the taking of evidence, where you have this very carefully thought through middle ground, whereby documents are important, but you have to be very specific with the categories, specific with the dates, and explain why they're relevant, as opposed to the sort of US litigation. You give us everything that's remotely connected, and we'll work out whether it's relevant. So I think that's been really helpful. I think as they've expanded, we've seen other rules. We've seen rules, the Prague rules on the efficient conduct of proceedings, which is more of a civil law approach. We've seen issues more recently of guidelines on party representative conduct, which is kind of interesting because I think this begins to get into some of, how does a tribunal address and what powers does it have to punish bad party representative conduct or bad party conduct. But I think that's the best way of addressing it, because there are always this sense of a lack of a sort of an equal playing field. Certainly, when you come from a common law background initially, when you're telling your clients in Latin America, no, you really do have to disclose those ugly internal emails, which are not big. How can we? Because it's not very helpful to us. That's not relevant. You've been ordered to produce them. So they're going in. And they think that you're somehow being disloyal and then you have a different approach from perhaps a civil lawyer. So you need to have something that balances it out, and I think soft law does that. And I think just generally, I'm a very strong believer, as I would be, in a genuine arbitration bar. I think there are people who do this day in, day out. It's not something that you should dabble in and just do one arbitration from time to time. It doesn't necessarily have to be the only thing you do, but it should be something you dedicate a lot of time to, and that you know who the people are in the field, and that I think there is a loyalty to the profession of arbitration practitioners, and and who understand how these things are to be done. You know, when I've got counsel opposite me, you know, whether it's my good friend Eduardo Silva or Fernando Mantilla from Colombia or Eduardo Damião from Machado Mayo or whatever. I mean, you know we're not going to have any difficulty in reaching a procedural agreement. We know how an arbitration is supposed to look. We will agree 99.5% of the points on a procedural order. The issues we'll be fighting on will be calendar and maybe or not whether there's a bifurcation of an issue. But the underlying, if I get someone who's from outside of the arbitration profession, you know, I may have to have, you know, a sort of a 6-hour procedural conference because they're not recognizing what the practice is. So they're fighting me on everything. And so it becomes much less efficient. And so, you know, and there's a different cultural approach because they're coming from a judicial approach. And so they're trying to replicate, you know, what the rules of court are in Guatemala or wherever it happened to be coming from. And that doesn't work. So I do think it helps a lot for clients to realize that, you know, when they're hiring lawyers, you know, you need to hire arbitration lawyers. You know, you don't hire, you know, you don't hire your litigation lawyer to run an M&A. You shouldn't be running a judicial litigation lawyer to run your arbitration. You know, this is a specialized world with its specialized conduct and rules, and it's going to be much more efficient if everyone knows what those rules are and how an arbitration should be run. But I think that's the main thing of overcoming cultural differences: having a basic set of rules, and secondly, a bar that understands what those rules are.
Yeah, this is also very important in terms of efficiency, right? It's much better to have as an opposing counsel a person that has already been involved in arbitration proceedings. You are right. Otherwise, you will be discussing things that should not be discussed, and it affects the proceeding in terms of time and cost and efficiency. Right?
Absolutely. I mean, yeah, as a young arbitrator, quite often you get given very low value cases, you know, when you're starting out, and you know, you come across two parties. I had one sort of a French counsel on the other side, counsel from Turkmenistan, and I basically had to give them lessons in what arbitration was and how you're supposed to behave and what the different stages are. And it was, you know, it was really quite frustrating because you didn't, you know, the merits. Before we could even get to the merits, we had to just get a common understanding on how the proceeding would work, and neither of them had any idea. So, you know, you just waste a lot of time and effort that can not contribute to getting the thing done quickly.
Okay, but by the other hand, you mentioned in the beginning of our conversation that there is a movement towards diversity and inclusion in arbitration.
Yeah.
So do you see real changes in this field, and would this idea of having this arbitration bar would go against this idea of inclusion and diversity in any way?
Good questions. I mean, the second one. Yeah, I mean, I think there's been in the last 7 years since our last edition, I mean, there's been a very material change in the balance of, I think, overall in the field, but particularly in the balance of arbitrators, although we're not there yet. I think now there's this far greater number of female arbitrators sitting in important cases, including as chair. I mean, I was just doing a count before our discussion. You know, I've got 5 pending cases. I mean, 5 of my pending cases have women who are presidents of those cases, all of whom are under 50 years old. Whereas if you took that back 10 years, there were a couple of very well-known female arbitrators, but if you took them out of the equation, there were virtually none others. Those particular 2 female arbitrators who were very well-known were very well-known and very well-regarded, but there was very few others. So I think it's been great to see that change. I think it's injected not just a different perspective, but also youth, because I think the sort of the fallback was not just about appointing too many males, but appointing too many old males. And I think that you're now seeing arbitrators who are much better prepared, who come in with very poignant questions. And it's just great. It's just great seeing a whole new sort of college of arbitrators who've not been there for 20 or 30 years and who are highly competent and who've been practicing as arbitration practitioners, know exactly what they're doing, what the rules are, but on top of that are well prepared on the merits. So, it keeps us on our game as counsel when we're acting as counsel. But it also makes you feel that it's worthwhile, all the preparation you do as counsel, because sometimes you prepare a very complex, difficult brief and you sit in front of the tribunal sometimes and you say, have they actually read any of this stuff? And now you don't. I think with the youth and with the diversity, we're changing that. I think there's still a way to go in terms of other types of diversity. I think racial diversity is still poor. I think there's a movement now called Racial Equality for Arbitration Lawyers, which I hope is as successful as the Equal Representation in Arbitration Pledge. But I think we've moved a long way from the sort of pale male and stale approach of a few years ago in terms of the arbitrator core. The second point you make is interesting, which is to say, well, yeah, but if you've got an arbitration bar, aren't you somehow sort of limiting the possibility of diversity? And I think the answer there is no, because I'm not trying to suggest that who can get into the arbitration bar should be limited. We should make sure that there's plenty of diverse opportunities to get into the arbitration bar, but that what we see is that arbitration is a specialty, and that once you get in and you practice and you develop your networks, and hopefully when you get a more diverse bar, then that becomes a virtuous circle, because each person will have their own networks that will naturally perhaps reflect more who they are, and therefore you will get more people who think like them and have a more diverse aspect than those that are already perhaps dominant. So I think the issue is making sure that the law firms that are recruiting, the institutions that are nominating, and the lawyers are brave enough when proposing candidates that they propose diverse candidates. And sometimes it's a bit of a fight. You've got, clients tend to be very conservative. They want the person that sat in 20 arbitrations. And if you tell them, yes, but they're 81 years old and they've got probably too many cases, and, we're not sure that they're going to be that well prepared. Wouldn't you prefer someone who's 45 and, and likely to have more time and energy and is equally, if not more intelligent? And, depending upon the client, you can get through to them and they're prepared to take what they would see as more of a risk, because they're not nominating if they lose, they can't be blamed for nominating X or Y because they're a well-known person. Whereas if they lose and they've nominated someone who's relatively unknown, then that could potentially be a point of criticism from their management. But I think it's also part of our job to advocate for the diverse categories of arbitrators, and I think it's happening, and it's a pleasure to see, because I think I was quite cynical as to whether it would happen, but finally it didn't happen in the first couple of years, but now there's a sort of a real momentum, and I hope that continues.
Well, unfortunately, I think we are running out of our time, so I have just a few questions left here for you. And one is, what is your advice for young practitioners that want to become international arbitration counsels or arbitrators?
Yeah, I mean, if you follow my example, it's don't organize anything, don't study arbitration, and just fall upon it by accident, and you might be lucky. That was my route to success. I think in terms of now, of course, it's a very different world than it was back in 1991. What's important for international arbitration? Obviously, be international, study international law, but perhaps just as important as international law is comparative law. Understand as much as you can and take as many courses as you can whereby you're looking at both common law and civil law, because ultimately in arbitration, you're applying domestic legal systems for the most part if you're not doing investment arbitration. And those domestic legal systems will fall into one of two categories, civil law or common law. And I think one of the huge advantages I had was having studied French law at university, was that I understood what it meant to reason from a code as opposed to reasoning just from case law. And being able to understand that perspective meant that it didn't matter if it wasn't French law, but if I'm looking at a Brazilian law case or a Chilean law case or a Colombian law case or a German law case, I know the way that the lawyers are thinking because I've studied that system deeply. So I'm not just coming at it from a common law perspective and trying to impose my common law thoughts on that process. So the ability to understand the reasoning of a common lawyer and the reasoning of a civil lawyer, I think, is really important. So try and get a double training in some way. Obviously, learn languages. I mean, I think if you're going to be in an international environment, obviously English dominates arbitration, but Spanish and Portuguese are pretty damned important as well. Russian and French also have their role. One thing I do advise is don't try and become sort of the international arbitration lawyer from day one. I think everybody has to be trained in a legal system. You have to have a legal culture. And to have a legal culture, you need to spend some time in a legal system, in a single legal system. I was an English lawyer first. From 1991 until probably 1990, for the first 10 years of my practice, part of my practice was practicing English law. From 2001 onwards, I became a dedicated international arbitration lawyer. But before then, I learned to be an English lawyer and to understand one legal system really well, because otherwise you're a bit stateless. You're sort of, I'm an international lawyer, but that's not a real lawyer. You have to be qualified somewhere. What is the system you really know? Because once you know a system really well, you can reason from that. You can say, well, I've seen a problem now. From my perspective, under my system, we would do this. Now, there may be a different solution, but then you have a starting point. If you start off with sort of international law or comparative law, you don't really know one system deeply, then you're a little bit orphaned or stateless. I think don't rush into it. There's plenty of time in your career to become an international arbitration lawyer. Make sure that the first couple of years you really become a really good Brazilian lawyer, a really good English lawyer, a really good French lawyer, and then focus on the international law, which is why I think the LLM solution after a number of years domestic practice is a really good solution. In the States, it has the advantage that it gives you a visa to practice for 1 year or to work for 1 year after your LLM. And if you're lucky enough to get a foreign associateship in an international arbitration practice, that's a wonderful experience. I've recruited 90% of my Latin America permanent team from foreign associates who've come through that process. So if you want to work internationally, that's a great route. But even if you don't, having 1 year's experience working in the States in international work is fantastic. But there are other routes through Europe as well. But also now, obviously in Brazil, which has developed arbitration jurisdiction, where there are arbitration practices in big Brazilian firms. So find out what those firms are, focus on those firms and get in front of the right people and try and bring something interesting, try and bring a cultural perspective. I mean, to me, I think I was lucky enough, I spoke Spanish. I was really interested in Latin America. And I kind of focused on that. I wrote some articles, I edited a book, and I put myself out as being really interested in this area. And bit by bit, you kind of get known as Miss Latin America or Miss Russia or Miss Asia or whatever it is. And then you're seen as the sort of the cultural entry point. And I think if you speak the language and the culture, and understand the culture, you can be successful, because I think clients want someone who can help not just decipher the law, but decipher the conduct of the other party and how you're going to get to a solution. And also how to work with local counsel and respect local counsel. I think there's a lot of arrogance from international counsel towards local counsel, which is wrong. You can't do any international investment case. Yes, it's international law that applies, but it happens in the context of a domestic legal system. So you need to understand that and work with them. But the other thing is, make yourself known. Try and write. Try and participate in blogs. Try and participate in the young arbitration groups. And just work really hard. And enjoy it. I mean, you have to enjoy it. If you don't enjoy it, you won't do something else. This is too absorbing as a job. If you don't have the energy, you don't wake up in the morning excited at the prospect of doing 10 different things, but not quite sure about when you're going to go home from the office. That's the nature of the job. But I still wake up every morning loving what I do, and I've been doing it for a long time. So I can only encourage everyone who has this to follow that dream.
We can tell that by your comments, especially when we were talking about the hearings, the adrenaline involved on the hearings. So it's something very clear that you really enjoy what you do, and I also believe this is something crucial for our career, right?
Absolutely, absolutely.
Well, I'm almost there. I would like to make a final question about the book specifically. We know that Martin Hunter sadly passed away during the preparation of the 7th edition. What legacy did Martin leave to the world of arbitration, and how important has his vision of the book been to the remaining authors?
I thank you for that question, because I think it's very important. This was Martin's brainchild. So this book wouldn't exist without Martin, and I wouldn't be talking to you about it without Martin. So he was a true visionary who understood the importance of arbitration very early on, and he saw it genuinely as a means of ensuring, I think, dialogue between nations and dialogue between disputing parties in a manner which was to be resolved in a civilized way. He was, I think, one of the very, very generous with his time. He was a mentor to me and a mentor to so many others. And it really gave meaning to the word mentor. He would spend real time with you, explaining issues. And when he retired from Freshfields, one of the things he did principally, as well as continuing to act as arbitrator, but probably half his time was spent teaching and mentoring different groups of students. And he had different research assistants, about 24 research assistants over time, that he gave different numbers to in a very typically humorful Martin way. And he had this enthusiasm for arbitration, which never left him. But he communicated that, particularly with regard to perhaps jurisdictions which until then hadn't received the attention. He was very focused on India and on ensuring that young Indian lawyers had the ability to shine in the world of arbitration. And he also had a passion for Brazil, and he worked quite a lot with the University of Sao Paulo. And in fact, 3 of his last research assistants were all Brazilian. We got Valerio Salgado from Sao Paulo, Vitor Castro from Porto Alegre, and Renan Frediani Torres Perez from Sao Paulo. So I mean, I think he knew the importance of Brazil. And how influential Brazil would be, and he was very keen that there were young Brazilian lawyers under his tutelage who would benefit from his wisdom. As for the book, I mean, he was the one who gave us the style guide that told us, we should write in short sentences, that we should focus on getting the idea across and not being an encyclopedia. We should keep it the same length. The book has never grown in size. If something has to go in, something has to come out. And constantly on our backs to make sure that the wretched thing happened, because of course we're all busy practitioners, and Martin was always the one that made sure we kept to deadlines and that we gave it the importance that it deserved. And his amazing sense of humor. I mean, we used to have terrific fun working with him and Martin on the different editions, and indeed he was working on the beginning of the 7th edition. I mean, he gave a lot of input into the strategy and structure of the 7th edition before he became more sick. And we're very grateful for him for that. We all kind of knew that at some stage this would happen and that there would be a full transfer of generation, but it was very shocking when it eventually did happen. We're extremely lucky to have Alan, who I'm pleased to report is in fine health and as sharp as ever, and one of my great friends, and we very much look forward to having him along. He claims he doesn't want to work on the 8th edition, but I'm sure we'll convince him otherwise as we move forward. But Martin left an amazing legacy, and both to the world of arbitration, to the world of education in arbitration, and I think ultimately, in a small way, to world peace, because of the way in which he thought about the idea of arbitration.
And are you already thinking about the 8th edition?
Alan has already told us we have to think about the 8th edition, and we've already had our first meeting for the 8th edition. So it never stops. It's like painting the Eiffel Tower or painting whatever it is. So as soon as you finish, you have to start again. But we keep notes about the developments as they go along. It's much easier to keep notes as you go along rather than just focusing on the 2 years before the edition when most of the writing gets done. Is to make sure we keep a hook on important developments So yeah, Constantine and I are in regular contact, and we've worked together for over 20 years. So that helps in terms of the communication and moving forward.
That's good. Well, Nigel, I have a last question for you. It's a last question, but not less important than the previous ones. It's not actually related to the book, but I would like to know if you could tell us a little bit about your pro bono work, because I've seen in your LinkedIn that you have been developing some very interesting pro bono work related to animal protection. So could you just go a little bit on that for us?
Thank you for that question, Vânia. Yeah, no, it's as a result of the pandemic, one of the things we sat down, you have a lot more time to think during the pandemic, you're not running around in the same way as before, was the way in which the pandemic had been generated. We were almost certain, and I think the evidence has now shown, from a spillover of a virus in the Wuhan animal market in China. And if you looked at the conditions of that market and the way in which that virus had spilled over, it was the conditions that animals were treated in that market were absolutely appalling. I think one of the commentators called it a cauldron of contagion. So that got me thinking. I was part of the international animal law section of the American Bar Association, and there was a very interesting speech by a professor called David Pfaff from Michigan State University, who had proposed a treaty on animal protection, basically providing minimum standards internationally for the protection and welfare of animals. There is no such treaty in place. There's no international protection of animals other than under CITES, which is basically on the interstate trade of endangered species. Other than that, it's really up to every country how they treat animals. And we felt that this was ripe for international standards, because until there were such international standards, then kind of the weakest link in animal protection is the weakest link to the next COVID. And so even if you don't care much about animal protection, you care about public health, then prevention of the next pandemic requires international standards to be applied for minimum animal welfare. So with all of that, I was lucky enough to get together. I wrote to David, and we got together with several eminent international animal law professors and with the backup of some of my colleagues at Freshfields, and began working on a revised draft of that international convention on animal protection, which you can now see on our website, which is conventionalanimalprotection.org. And if anyone watching this is interested, please do get in touch personally. We have outreach programs. We have a website, which is the one I've just given you. And we now have an NGO, which is called the International Coalition on Animal Protection. But our aim is to have that treaty supported by different member states and passed eventually, in order to ensure that we have a world which is safer both for animals and also in terms of public health and the environment, because they're all very closely linked. It's a complex science of viral transmission and various other things, which I've learned a lot about, very interestingly. But ultimately, this is something which I think is important for the future of the world, both in terms of pandemic, but also in terms of the way in which we look at the environment and our relationship with animals as we move forward. We want to be clear, we're not an animal rights organization. We're just trying to establish minimum standards for animal welfare, with the emphasis on basic foundational standards, so that each country can sign up to it. And if everybody does that, and the pressure is on to do that, then we can reduce pandemic risk and also be kinder towards other sentient beings that we share this planet with. So it's been fun. It's been a great exercise. It's a big fight. It's a long fight. It's one I will carry with me and my colleagues for many years. But it's something that I think the international law background and arbitration has helped prepare me for, because when you're drafting an international treaty and you're thinking about the way international law works, obviously having worked with international law in a commercial sense, it helps a lot in terms of how to go about structuring such an instrument. But it's been.
Nigel, that's a very, very interesting, very beautiful. Congratulations for the work you've been doing. And well, I think we are totally out of our time here. And I think we had a very nice and interesting conversation. I could be here talking to you for hours. I could add like more 50 questions here to our conversation. So maybe next time you come to Brazil, we can meet for a coffee and talk a little bit more about international arbitration, about your career, about the book. And I would like to thank you for your time. And that's it. See you next time.
Thank you very much, Vânia. Thank you for Arbitration Channel. This has been a great pleasure. And we will definitely have that coffee next time I'm in Brazil, Vânia.
Okay, so thank you very much. Bye-bye.
Thank you. Bye-bye for now.